68 of At Your Service with Haber and Martinez. I am Haber, below me is Martinez, and today we are joined by our guest, Jeffrey Feiler, a colleague and friend of both Ed's and mine, who's been practicing law here in Florida for longer than Ed and I. I'll tell you a little bit more about Jeff in a moment, but first let me tell you what our show is about today. I've captioned the show, A Comprehensive Analysis of Federal and Florida THC Laws. So really what we're going to be talking about is weed, marijuana, the loco weed. We're going to be talking about the law, how it has evolved and where it is today, both federally and with regard to the state of Florida. And we'll touch on the laws of some other states. As you're going to find out, Jeff Feiler has an intimate understanding of the laws of Colorado. He is a licensed attorney in the state of Colorado. And I do want to make one preface by saying that while we may touch on some other states and what they do, none of us are licensed in any state other than Florida with regard to Ed and myself, and Florida and Colorado with regard to Jeff. So we are not offering any commentary or advice with regard to any other state law, even though we may touch on it just a little bit. So pretty much everybody knows that marijuana or THC or pot or weed or whatever you want to call it is federally illegal. There's a little ditty called the 10th Amendment that allows states to make their own rules and regulations so long as they don't conflict with federal law. And then there are conflicts with federal law, even in spite of the 10th Amendment. And that's what we have with weed right now. So some of you may recall the prohibition, and that really related to alcohol. There was a period of time where the Volstead Act was passed by the United States Congress, and basically it outlawed alcohol. That didn't last all that long because the country lost its mind, and by the way, created an awful lot of opportunity for organized crime, and was really in part the genesis of what became the mafia. With that said, marijuana has undergone a kind of similar transformation and is slowly, much more slowly than alcohol, working its way back towards decriminalized mainstream use, as opposed to people having to do it under the table because people are going to do what people are going to do as a general rule of human nature. With that said, again, let me introduce Jeff Feiler. Jeff has been a practicing lawyer since 1982. He started at the Miami-Dade County State Attorney's Office under the late, great Janet Reno. And he has been his own practitioner, Jeff Feiler, PA, or the Feiler Law Firm, since, I believe, 1986 or 1987. Jeff does both state and federal criminal defense work, just like Ed and I. But as I said, he's also licensed in the state of Colorado. And interestingly, Jeff was a forerunner, a forefather, so to speak, of the medical marijuana industry, in that he and his family business received the first in the country, I believe, medical marijuana certification in the state of Colorado. So since about 2010, the Feiler family has been in the, boy, I hate to say it like this, but it's true, Tony Montana, they've been in the dope business in Colorado. The legal dope business.
They've been in the pot business in Colorado, but it's legal, so it's okay.
Yes, the legal marijuana business, and he is now pending licensure here in the state of Florida to break into that field, which is another area that we're going to be talking about during today's show. So it's really primarily geared toward understanding the law, but also understanding the industry. And this has become a multi-billion-dollar industry, which has some really interesting positions to it, especially when you consider the fact that the federal government doesn't recognize this as a legitimate business. So imagine, all those billions of dollars that can't be dealt with in the banking system or in the credit card industry. But we're going to let Jeff talk a little bit more about that. With that introduction, welcome everybody. Thank you guys for being here today. Ed, good to see you. Jeff, thank you again.
Michael, Ed, great to see you. Looking forward to doing the show with you today. So where would you like it to start, or would you like me to just
how about we start at the beginning? What have you seen? I think, Mike, I know it's your show, but let's start at the beginning. How did you get into it? What have you seen the differences evolving, how it's evolved to where we are in Florida? Colorado, I think, is now recreational, right?
Oh yeah, Colorado's been recreational
How-
for
What have you seen
decades.
in the evolution of the law regarding marijuana?
Well, as Michael had started to allude to, the original prohibition in 1937, the federal government created something called the Federal Bureau of Narcotics, and that's really sort of where the illegalization of controlled substances began. There are various schedules. Schedule 1 federally, essentially being the most serious judges and drug offenses, and by definition, those are all sorts of substances that have, quote, no medicinal value, which is sort of ironic when we have 30 plus states that have medical marijuana laws, and the federal government still considers marijuana to have no medical value whatsoever. In any event, so from 1937, and by the way, Reefer Madness, the movie, if any of you have ever seen it, was effectively a public service announcement. I remember I must have been like second grade when they played the movie in the school auditorium, with maniacs running around, killing people while under the influence of marijuana.
Wait. Are you trying to tell me that the government put out an ad, a movie, and they were lying about this stuff and trying to scare the crap out of people to make sure that they did what they wanted them to do? No, Jeff.
It was actually a public service announcement. It was absolutely amazing.
Well, the good
Anyway,
news is Cheech and Chong set the record straight in the early 70s.
Yeah, but apparently the government hasn't learned their lesson. But anyway, continue.
I'll be holding up my Big Bamboo album right about now. The paper's gone. In any event, it's not until about the year 2000 that California, I think in 2000, actually had a state constitutional amendment. But as a practical matter, because of the federal illegality, California really didn't do anything with that for the most part. It wasn't really until October 19th, 2009, when the Department of Justice came out with something called the Ogden, OGDEN memorandum, which was to give guidance to United States attorneys around the country in regard to states that were in the process of essentially legalizing medical marijuana. And the memorandum essentially said that if a state has marijuana laws and if there's robust enforcement of those laws, that the U.S. attorneys are essentially guided not to interfere with those. And with that, at the end of 2009, beginning of 2010, the state of Colorado, per their constitutional amendment, then started to pass statutory provisions enabling medical marijuana. And on July 1st, 2010, the first provisional medical marijuana laws went into effect, and people were able to begin to open businesses in Colorado. The businesses had to be vertical in the sense that that the business had to have basically cultivation. They had to grow marijuana, have production facilities where they can make products like gummies, and also have retail stores or dispensaries. So you had to be vertical, under Colorado law for medical marijuana, and that's basically essentially where it started. As things started getting rolling, and by the way, all puns are intended and acceptable.
Good. So I was going to mention, is that where they called the Mile High? What is it? Is it Denver? That's the Mile High, Mile High city.
5280. So yep, they're high without even getting high. But yeah, but essentially, as things started to pick up and facilities start getting built, large commercial cultivation operations are underway. So August 29th, 2013, a second Department of Justice memorandum called the Cole, C-O-L-E memorandum comes out and basically says, again, giving guidance to U.S. attorneys around the country that, listen, we don't care, the feds say, we don't care what the size of the operation is. We don't care how large the commercial facilities are. We don't care what the quantity is that's being grown, that's not the criteria for U.S. attorneys' offices to take any kind of legal action. And they set forth a number of provisions that would invoke essentially federal criminal laws, selling to minors, moving across state lines, and things that are clearly illegal. So that was essentially the legal framework that, although under the 10th Amendment, there's the states have certain rights that and so forth, but as a practical matter, the Federal Supremacy Clause is the Supremacy Clause, and the federal drug laws are therefore supreme over the states' rights when it comes to this, because it is legislated. But really, until January 10th, 2018, when Jeff Sessions, in his infinite wisdom, rescinded the previous Ogden and Cole memorandums and essentially left the U.S. attorneys' offices around the country with no guidance, so to speak. That was essentially the change. Fortunately, he was kicked out of office, and as a practical matter, nothing has really changed in the way that the U.S. The government has been treating the states. More and more states have come on. A majority of states have at least medical marijuana laws. Many have recreational marijuana laws, and the industry is fairly firmly planted at this point. Right. Also, as Michael pointed out, there have been efforts to decriminalize marijuana, such as the MORE Act, which they tried to get passed in 2019 and 20. That didn't go through. And originally the Safe Banking Act, essentially where banks would not discriminate essentially against cannabis companies. In other words, banks could bank. The Safe Banking Act never passed. They tried to slip it into a variety of agricultural acts, especially when CBD. It never worked. But as recently as April 26th of this year, a number of senators, mostly from marijuana states, like Oregon and so forth, got together and just enacted the Safe Banking Act of 2023, which once again would have to go through the legislature. But up to this point, there's no Safe Banking Act, there's no decriminalization, there's no federal guidance, and there's a lot of states that have medical and recreational marijuana laws. So that's kind of the quick background on legal.
Let me plug in two little things here. One, Ed and I are oftentimes talking about how, and certainly you're aware of this, every judicial circuit in Florida is different. And so similarly, every state is different. Even every U.S. attorney's office is different, right? We have three different federal districts here in the state of Florida. I would venture to say that the Southern District operates a little bit differently than the Central or Middle District, which operates a little differently than the Northern. So we're always kind of talking about how prosecutors and public defenders and even defense attorneys need to kind of tailor themselves to the judge or to the jurisdiction, right? So even here in our local Richard Gerstein Justice Building, you can be in front of one judge that's a traditionally state-oriented, very difficult judge where you're going to get very unfavorable plea offers by the state, whereas the other assistant state attorneys from the very same office in a different courtroom in the very same building are going to be in front of a very liberal-minded judge, and they're going to wind up giving very different offers. So that long-winded statement aside, basically what I'm trying to get at is if you're in, and just statistically so that the folks know, as far as the federal government goes, pot in all forms is illegal and has no medicinal value. It is completely unrecognized. It is not accepted in any way, shape, or form as a matter of federal law. That said, there are presently, as of today, 38 states, 3 territories, and Washington, D.C., which have authorized and implemented medicinal marijuana, meaning that if you are diagnosed, if you are given a prescription by a recognized medical provider, and if you then fill that prescription at a licensed dispensary and you use your dispensary purchased product pursuant to your doctor's instructions, it's legal in 38 of the 50 states. That is the vast majority. Only 23 of our states and one territory in the District of Columbia permit what we call recreational use, meaning you can buy weed if you're not a disqualified person, if you're not a minor or whatever, you can buy weed just like you could buy alcohol in a weed store in any form that you wish, because again, it is of recreational use. And there are only 6 states in this country that have no provision whatsoever for what we would call any form of legalized marijuana. So 6 states follow this federal model. So with all of that talking, what I guess I'm trying to ask you, Jeff, is, in your experience, would the federal authorities treat dope or dope cases or dope incidents, or the way that they pursue them or not pursue them differently in a place like Colorado, where you have recreational, versus a state like Florida where you have only medicinal, versus a state like Idaho where you have absolutely no right whatsoever to touch or use or possess or cultivate or sell marijuana?
All right. Well, as you point out, let's use the state of Florida as an example. So the state of Florida has 3 federal districts, as you mentioned, and has about 50 something different counties. And each county, essentially politically and based on the personality of the state attorney for that particular circuit or area that they're in, treats things differently. So all of the above is true. As a practical matter, the federal government rarely gets involved in small cannabis cases. When I say cannabis, I'm talking about marijuana cannabis and not CBD, not hemp. So, but as a practical matter, you just don't see small marijuana cases in federal court. It's probably going to be certainly in excess of 20 pounds, probably more like in hundreds of pounds. And they're dealing more with cartels, Colombia, Mexico, etc. When you're dealing in federal cases, you just don't generally see small marijuana cases. Even if someone were to come in through the airport and with a relatively small amount of marijuana, even though they'd have initial contact with Border Patrol or Customs or whomever, it would still be deferred to the Broward Sheriff or the Miami-Dade police department, Brevard, whoever
you come
it is.
off of a cruise ship at the port of Miami after your trip to Jamaica, and you have that little satchel that you forgot to either dispose of or consume, and you get nabbed at the port of Miami. You're not going into federal custody. If you get taken in at all, you're gonna be taken over to the TGK.
Right. And it's always task force stuff. So you're going to have multiple agencies down there at the port, including, for example, DEA, Customs, Border Patrol, Miami-Dade Police Department, others, Homeland Security, etc. And for a small amount of weed that comes in, it's going to get deferred over to the state. Bottom line is that more than 20 grams of marijuana in Florida is a felony. Less than 20 grams is a misdemeanor. And there's also an option when you're down in the misdemeanor realm that the police could actually just write a civil citation, like a traffic ticket, with $100 fine.
That's not a matter of state law, though, correct? That's a local jurisdictional law. So in Florida state law, like the feds, possession of marijuana is criminalized across the board. But some smaller jurisdictions inside the state of Florida, like, for example, Miami-Dade County, the city of Miami Beach, Pembroke Pines, what have you, have passed their own ordinances that allow officer discretion to charge what would otherwise be a misdemeanor offense, but only a misdemeanor offense, as a civil infraction, where, as you said, they give you a payable ticket that comes with no criminal stigmata. But even then, there are restrictions on that, because some of those jurisdictions, obviously I don't know the rules for all of them, but some of them have officer guidance. For example, if you have already been given a civil citation once, some agencies do not permit them to give you a second.
Right. And I don't know if you want to touch on this now, but while some counties like Dade County, they're not actively pursuing small amounts of marijuana, they're not charging those. Law enforcement is still using the odor of marijuana.
I want to get into that, but let's do that a little bit later, if you don't
Okay.
mind. And also make a mental note that I want to talk about grow houses and cultivation,
Okay.
because obviously that's something that's still very much pursued here in the state of Florida anyhow.
Right.
Yeah. Before we leave this subject, though, let me mention something else, and that is we've been talking essentially right now about flour, and essentially less than 20 grams constituting a misdemeanor. One of the real aberrations is concentrate, and that is if you have a vape cartridge, if you have a gummy, or anything that is not flour, but basically THC in a different form, it's a felony. And it could be essentially a 5 milligram gummy is a felony.
That weighs far less than 20 grams.
Well, that would be essentially 5/1000th of 1 gram. It's 5 milligrams. I mean, the math is just in the tens of thousandths smaller than what would be necessary to constitute a felony. But because it's not flour, because it's concentrate, it's a felony.
I think that's a
So
very important pro tip for us to give to the folks right up front, because a lot of you folks out there think, well, I've got my vape pen, it's no big deal, and maybe the cop's going to think that it's a nicotine pen. No, they're not. They're going to test it. They're going to see that it's got THC in it. And if you're in possession of a vape cartridge, if you're in possession of a little piece of shatter or wax or resin, it used to be back in the day before they had all of these variations, it was either weed or hash oil. Those were pretty much the only three areas that you could have. But now it's expanded into so many different potential forms and shapes. And I think the point that Jeff was trying to make, which is very well taken, is if it is not physical, what we would call lettuce or plant-based traditional marijuana that you would roll into a marijuana cigarette, then it is any amount of it is a per se felony charge in the state of Florida.
Yeah,
correct.
So you guys,
I
call it a pro tip because you guys, the folks out there should be very well aware of it. That little vape cartridge alone. So let's say, and I guess we could segue into it for the moment, but this comes up very often in the context of like a traffic stop, right? You get pulled over and the officer sees your vape cartridge or your vape pen, and you figure it's no big deal because either it's a prescription product that you got from your doctor, right? So you're legally entitled to have it here in Florida, or it's an illegal product, but you figure you're going to get away with it anyhow because either the cop's not going to know what it is, or they're going to assume that it's nicotine. Or let's say that you have gummies or you have shatter or wax that's visible or available, to the open eye in plain view. You're going to wind up potentially looking at a felony now. And we'll talk a little bit later about motions to suppress, and we'll talk about the line of cases that dealt with the odor of marijuana being probable cause for an officer to search your vehicle, and then the questions that have been thrown in with regards to now the legality of hemp and the virtually indistinguishable scent, even to canines, between hemp and marijuana. But these are the types of things that you probably don't walk out of your front door thinking about in the morning. And if you watch this show, we want you to think about, because the last thing we want is for you to wind up with defending a felony charge over a 5 milligram gummy. So
that's right.
So let's get back to the state of Florida law, right?
Although I just got to add, it is good for business.
Let's get back to the state of Florida law, because Jeff was distinguishing between felony and misdemeanor violations here in Florida. Let's start with the premise that even if you're in possession of legal weed in Florida, legal weed meaning you are a medicinal marijuana patient, bona fide, licensed. You have legal weed that's been given to you by your physician that you purchased at a pharmacy pursuant to your prescription. That doesn't give you carte blanche to just use your weed as an excuse. It's still against the law to do certain things while under the influence of any controlled substance and or alcohol. For instance, you can get a DUI on weed. You can get a BUI on weed. you can get arrested, and correct me if I'm wrong, Jeff, but I believe I'm right. You are not permitted to use your medicinal marijuana in public. You can't walk down the street and smoke your dispensary purchased legitimate medicinal marijuana cigarette. You can't walk down the street and smoke that legally in the state of Florida, can you?
You're correct.
You're correct.
So what can we do here? Talk to us about what is legal in the state of Florida. How does somebody legitimately get a hold of weed, and what are their restrictions in terms of possession and use?
Well, you would go to a physician, a doctor.
Any doctor?
You would, sorry?
Any doctor or certain doctors?
Well, physicians, and essentially, for the most part, talking about doctors that practice medicine, MDs, DOs, and so forth. Those doctors are required to take a course, which then qualifies them to write recommendations, what we would call loosely prescriptions for medical marijuana, and designate, depending upon their particular ailment, the appropriate amount of marijuana type products, that would make sense for them.
I guess I was to lead you, Jeff, into you can't just go to any doctor and get a prescription. The doctor has to be authorized to write the prescription, right? Just because you have a medical license from the Department of Health here in the state of Florida does not automatically authorize you to write marijuana prescriptions.
Right, and these are not the kind of prescriptions that you'd find at CVS drugs, where the pharmacy,
right? But let's
start
with
they have a right, and you have to sort of distinguish between doctors, if you will, and prescriptions. The typical prescription that we think about is at a pharmacy by a pharmacist that has a DEA license, a pharmacy that's licensed through the DEA, which is all federal. And as we know, all of this is federally illegal. So therefore, a pharmacy, you cannot go to the CVS pharmacy and get marijuana. You have to go to a dispensary and get marijuana.
And by the way, that holds true everywhere in this entire country, not just the state of Florida.
No, everywhere in the country, this is true. Right. So typically a person goes to a licensed physician who has qualified, per the state's requirement that they do a certain amount of class time and so forth and so on. And now they're designated as physicians who have the ability to then write what we loosely call prescriptions. Some places it's called recommendations, that the patient be able to get medical marijuana. They then register with the state and they get a card, a registration number, effectively, and a quantity that for a certain time period that the patient is allowed to get. They then go to one of the licensed dispensaries around, and in the state of Florida, you're talking about True Leaf, Sutera, Curaleaf, and many others. You can go to a local dispensary, and they would look up your registration number. They would see in the computer that you're within the time period. They see how much that you've already obtained and how much more you're allowed to obtain under that particular prescription per se, and then that's how you get your weed.
So I think let me interrupt you just briefly for a second, so the folks understand. When we're talking about going to get your weed, again, Jeff distinguishes between walking into Publix pharmacy or CVS or Walgreens, where you're going to get your antibiotics or your painkillers or what have you. You can't do that with weed. Weed, you have to go to a weed dispensary store, a THC dispensary establishment, of which there are many. And in that establishment, they have a variety of products, right? I mean, they have plant-based marijuana. You can buy it pre-rolled. You can buy it not rolled in just raw form. They have it concentrated into what they call wax or shatter, or what we might call hash. They have gummies. They have mints. They have chocolates. Depending upon the place you go, there will be a variety.
They even have drops like
they have tincture, oil, liquid. Now, of course, if you go to a recreational marijuana state, they're going to have a much wider variety, and it's also going to probably be more widely available, since you don't have to go to a dispensary which is strictly regulated as it is here, in Florida. But that said, you have all of these different products, and whatever it is that you purchase, each product has its own milligram content. And so your prescription is going to give you a certain amount that you are allowed during the prescription period, whatever it is, every month or every 3 months, however your prescription is written, and you can't exceed that. So you're only allowed, like, it's similar to, let's say you have a prescription for Percocet, right? And your doctor writes you 30 pills for 30 days. You can't go back and keep buying more. You can only get what you can get pursuant to the prescription. The dispensary should not exceed the prescription, because if they do, they run the risk of being, called out and potentially losing their license and sanctioned. So they're generally going to follow that rule, as must you. So what you do with your prescription is your choice. We're not going to tell you to take your prescription and go supply all your friends with legal weed because you have it. But whatever it is you choose to do with your prescription, recognize that you're limited by the limitations of the prescription itself. I apologize for that, Jeff.
No, but you're right about that. And in some places, in like Florida, for example, you have limitations built into the prescription itself. In other places like Colorado, you don't have any particular limitation per the prescription, but the dispensary has a limitation in the sense that they cannot sell to you more than X amount in a given day.
Now, they take your identification. They know who you are when you come in the door. There's no, it's unlike alcohol, where you basically walk into any liquor store, they card you. I don't know who's beeping there, but somebody's beeping.
Me, sorry.
They may card you just to make sure that you're 21 or older, right? Because they don't want to get accused of selling alcohol to a minor. But there's no limit. You can go in there and buy 50 cases of wine if they have it, or 20 bottles egg, whatever that is, kill it.
I'm trying to cut it off. I don't know how to turn it off. You keep working. I'm trying to cut it off.
You can go in and buy as much alcohol as you want, but it don't work that way with marijuana. Now, is that the same as in a recreational state like Colorado? So if I want to go in and buy 10 million gummies, are they going to cut me off?
You can't buy, I believe, more than 100 milligrams of edible at one time. I don't think you can buy more than 1 ounce, in one day. You can't really bounce from dispensary to dispensary. You can't possess more than 2 ounces at a time.
Another question: do they have, like, here there's a crime on the books in Florida called pharmacy shopping or prescription shopping, right? Where you go to a doctor, you get one prescription for whatever it is you want, then you go to another doctor and you get yourself another prescription for the same thing. And you go to a third doctor. In other words, you're basically stacking your prescriptions. You don't tell any of the doctors about the other doctors that you went to because you're trying to get more meds. But the pharmacies keep track of everything because you have to use your identification. And they're all required to communicate with one another. That's one of the benefits of being in the federally scheduled system, right? But weed is not federally scheduled. So do they have the same type of internal approach that they use to tracking an individual's purchase?
Well, for example, in Florida, let's suppose, and just to pick a number, that you were allowed to get 3 ounces of flour, per your prescription. When you go in there, you have a registration number, and they can see how much you have already received. So if you go to Curaleaf, get some, and then the next day go to another dispensary, they will see where you are relative to what you have left.
So they all communicate. They have a database that they all tap into.
Right. The registration number is in the database, and everything's calculated, essentially, on the spreadsheet of that particular registration. Now, in Colorado, by contrast, you don't have a number per se. The dispensaries that actually have gotten into trouble are ones where they can't sell you more than 1 ounce at a time. So a person would go in and buy 1 ounce, and they'd come back 2 hours later and they'd buy 1 ounce, and they'd come back 2 hours later and buy 1 ounce, and they would just keep going round and round, and end up buying a half a pound. by the end of the day. Those are the dispensaries that have lost their licenses because they're seeing the same guy, just essentially a revolving door of going round and around. And another thing is, let's go to dispensary 1 and buy an ounce, dispensary 2 and buy an ounce, and then dispensary 3 and buy an ounce. You're only permitted to be in possession of 2 ounces at a time.
In Colorado,
so
that is.
We're talking about Colorado in contrast to Florida. So in Colorado, it's not measured by an amount under the prescription. It's measured by the amount that a dispensary can sell you and the amount that you can legally possess at any given moment. 2 different systems, and so forth. Now Colorado is recreational at this point, so it's a little bit different. But what I would encourage everybody in Florida is, to the extent that you have it, let's say in your car, you're not allowed to smoke it. It's not a private place. And also you're looking for a DUI if you were to do that, or you're looking to get your car searched if you were to do that. But point being is that you should keep it in the little white or whatever colored container that you get your prescription in, that has all the prescription numbers and everything on that little container. Because if you have it in a bag and then you claim that, I have a medical marijuana card, okay, that may very well be true. But you're really a lot safer, if you have it in your closed container, and say, hey, I've got a medical marijuana card, and here's my little container of it. Then you're in pretty good shape.
That dovetails into our age-old law enforcement adage that you might beat the rap, but you won't beat the ride.
Mm-hmm.
Oh, for sure. For sure.
So let's talk a little about automobile stop, because I think that's a biggie. Boats and cars. Obviously, boats are a little bit different because you have very limited Fourth Amendment protections on the water, and marine law enforcement can stop you without any probable cause just to do a safety inspection or a compliance inspection if they believe that you were fishing or diving. So the rules are a little bit different on the land. They actually have to have probable cause that you committed some violation of traffic law or probable cause that you committed some other offense. But if you're pulled over for a normal routine traffic stop, like speeding or sliding over a dividing line or having defective equipment, even the most innocuous of charges that you don't know. Maybe you have a broken taillight that you weren't aware of, or a bulb that's blown out that you had no clue. If they get to your vehicle and the window gets rolled down and the officer detects an odor of what he or she believes, based on their experience, to be marijuana, that's enough for them to get you out of the vehicle and search your vehicle. That's boilerplate law in the state of Florida, correct?
That is correct.
Yes.
Now, there was some issue that came up not too long ago when hemp became a legitimate product in CBD, and hemp now became over the counter, that there was an argument being made that officers and even canines could not distinguish between marijuana and hemp. And therefore, there were some courts that were sustaining challenges of odor stops or odor searches, let's call them. Do you know what the status of that is as of today?
I don't know what the legal status is per case law, but I think that my understanding is that so far as providing probable cause,
Correct,
that if an officer smells the odor of marijuana or of the odor of cannabis, that constitutes probable cause. And it may turn out later on to be CBD and have essentially no THC in it at all. But remember, probable cause is an extraordinarily low standard. And I think that's the state of the law.
I agree. I believe that there were a couple of courts that were sustaining the hemp argument, but it's basically been shot down at this point and gone back to the original. And the point being, again, if you don't have it in your car, and if you do have it in your car, but you're not using it, then the odds are you're not going to have a problem. But understand that if you've got your prescription weed in your vehicle and it reeks and it's got an odor, you're asking for trouble.
right. If I may, what I believe certain districts, and I think the third is one of them, what they said was, because marijuana is illegal unless it's medicinal, and that may smell like hemp, it doesn't mean that the officer, if he can't determine whether it's hemp or marijuana, then he has a right to investigate to find out what exactly it is that he's smelling. So that's why if he smells an odor of marijuana, he's allowed to look. Now, if he looks in your car and what he ends up finding is hemp, then he won't arrest you. So that's where we stand now. That's why don't think you can get away with that. And one other thing. Also, since the officer can't distinguish the odor of dispensary marijuana from street bought marijuana, that's why it also gives him the right to search your vehicle to determine what marijuana you actually have.
And for those of you hippies and people out there that are all into the hemp stuff and the CBD stuff,
What if we're not hippies?
The canine's not going to distinguish either.
Right.
So canine alerts, whether it's hemp, THC, CBD, whatever, you will be getting removed from your vehicle, and that vehicle.
Well, again, let's be clear. It gives the officer the right to search. Now, if you have hemp and that's all you have in your vehicle, even if the dog hit, you're not going to get arrested because hemp is legal.
Jeff, let's talk a little bit about some natural conflicts that come with medical marijuana here in Florida. I don't want to, stray too far into the recreational because we're not quite there yet. But here in Florida, again, you can have a prescription for medical marijuana, just like you could have a prescription for oxycodone, or you could have a prescription for Xanax, or you could have a prescription for Ambien, any of a number of things. We know that it was a prescription drug defense to a DUI or a BUI charge. So if you get arrested for DUI and you provide urine and they have THC in your urine, or if you get arrested for DUI and they find your vape cartridge in the car and it's going to be introduced in evidence against you, there's it was a prescription product, so therefore you can't prosecute me. That is not a defense.
Correct.
That said, let's talk about two things that come up very frequently with regards to prescription marijuana. One is, and it will be a non-issue, by the way. I guess maybe in one way it'll still be an issue, but it'll be a non-issue come July 1st when Florida becomes the 26th constitutional carry state in the United States, and we no longer have a requirement for a concealed weapons permit. But for the purpose of this question, when you have a medical marijuana card, can you also have a concealed weapons permit in the state of Florida? I'm not talking about federal law. We'll get into that in a minute. But just as a matter of state law, is there an inherent conflict between those two things? And as a follow-up to that, noting that, again, we will not need to have a CWP subsequent to July 1st of this year, will there be a conflict between having a medical marijuana card and simple possession of a weapon, again, as a matter of state law?
Mm-hmm. Well, two different things. But first of all, on the issue of a concealed weapons permit and also a medical marijuana card, we as attorneys didn't know what to make of that, and essentially was resolved by the Commissioner of Agriculture, Nikki Freed,
who had both.
Who had both, and she basically and publicly said, "I have both." And that's okay.
And so I assume that's going to carry over even after we become a constitutional carry state. But the point I want to make for the folks to understand is there are still laws that regulate your Second Amendment right when it comes to firearms and weapons and being under the influence of anything.
Correct.
That's alcohol and or any controlled substance, be it medicinal marijuana or illegal methamphetamine. It makes no difference. If you are impaired, you are not permitted to possess, much less use or brandish any firearm or weapon in the state of Florida.
Right, that's correct. Yeah, and in the context of DUI, for example, BUI, it's not really so much a question of the substance. It's a question of impairment. So, if you drank some Robitussin and you couldn't drive your car straight, it's completely legal over the counter and so forth. Right. But the BUI laws basically say that if you were impaired due to some substance, and it doesn't have to be, it could be a prescription substance. You could take a prescription, you could take an over the counter, you can take illegal, whatever the substance is. As long if you're impaired, that's the problem.
So if it reminds me, if you've seen the movie Tombstone, the great Western flick with Kurt Russell playing Wyatt Earp, right?
Right.
And so there's this scene where Powers Booth is like the main bad cowboy, right? And he gets all hopped up on opium one night and he goes out into the street and just starts firing up into the sky and howling at the moon, right? And then he winds up shooting the sheriff. Of course, things worked out pretty good for that character, but that was, back in the days of the Old West. But the point being, if you were to do that today, you got hopped up on your prescription medication, be it marijuana or whatever, and pulled out your guns and started howling and shooting at the moon, you'd be committing a variety of offenses.
Yeah, and not only would you be committing a variety of offenses, but you've essentially deprived yourself of the involuntary intoxication type laws. If you voluntarily intoxicated yourself, right, you've essentially eliminated that defense as well.
So either way, regardless of how Florida looks at it, so let's again just go back to the point, forget about constitutional carry for a minute. There's no inherent conflict in the state of Florida between having a CWP and a medical marijuana card. But there is a very, very, very clear conflict between that and federal law, because federal law does not allow you to use marijuana or touch marijuana. And federal gun laws do not allow you to purchase or possess or own a firearm if you are an illegal substance consumer.
That's correct.
Unless of course, you're Hunter Biden.
Correct. There's the Hunter Biden exception. Right.
So it would still be a federal issue, and you folks ought to be aware of that. Even if you have a medical marijuana card, and even if you are in a recreational use state, you still have very serious issues with regards to firearms and controlled substances. So be very, very, very attuned and careful to that. I mean, I don't care if you're out hunting in the woods. It's the same difference. When you're possessing that firearm and you are under the influence of alcohol and or a controlled substance, you are subject to some very serious criminal offenses. And I want to dovetail that one into probation, because I get this question a lot. I do a lot of work online, and I get a lot of people that ask this routinely. Can I use weed while I'm, can I get a medical marijuana card while I'm on probation? And my standard answer to that is always yes, but go to your judge. Make sure that you let the court know, because some judges, again, there's no inherent conflict. Just like the firearm situation here in the state of Florida, you can be on probation and be a medical marijuana patient. The same way you could be on probation and your doctor could prescribe you an antibiotic or a painkiller or a sleep aid. There's no medical prohibition for a doctor based on your legal status, but there may be a prohibition based on your legal status. So just because your doctor can do it doesn't mean your judge or your PO is going to like it. And my standard advice to folks when it comes to that is, your PO is the boss of you while you are on probation. Period, paragraph. The PO is the boss of you while you are on probation. However, the judge is the boss of your PO. So when in doubt, when you have a question, go to the judge, get an answer. Do you have a different thought on that, or anything you'd like to add to that?
Well, no, I don't have a different thought on that. And, my standard operating procedure is to go to the judge. When a client says to me, that I'm going to be on probation, can I use medical marijuana? I have a card. I'd say, let's take it up with the judge. Make sure, that you have permission from the court to do this, rather than, find yourself in a potential violation later on. And contrary to what I thought the case would be, I'm going to say that at least 50% of the judges in state court that I've gone to as essentially as a courtesy to obtain permission have not granted permission. They've said, they've told my clients, no, you can't use medical marijuana while you're on probation.
Have you ever had occasion to appeal that ruling?
No, because I didn't have any clients who violated, and it would essentially be a violation of a court order, if nothing else, even if it's not a probation violation. But down in, I had a lobster, like too many lobster and underside lobster case in Monroe County.
Well, that's an offense there, Jeff. They ask people for that.
That's why I
Sorry?
asked the county.
Yeah, they execute people for that down there.
Well, right, understood. But they didn't execute my client for that. But I did learn that on his probation, which had nothing to do really with lobsters, that it was the policy down there that you could not use a probation policy, that you could not use medical marijuana.
Hey,
Contrary, yeah. So you have the the various policies of the Department of Corrections in a given county, and you have the policies of judges and individual judges, across the board, and it's basically all over the place at this juncture.
so we've talked a little bit about probation. We've talked a little bit about Second Amendment, concealed weapons permits. What about professional licensing and security clearances? So what if you like work at the airport? What if you work at the airport, or you work at the Port of Miami, or you work for TSA?
Mm-hmm. I can't really speak to that because administrative, law and particular policies of a various agency are somewhat out of my wheelhouse. But let's face it, I mean, you can't work stoned. I don't think that there's, any workplace, whether it's a governmental workplace or a private workplace, that's going to say, sure, it's fine, do some opioids and come to work, or smoke some weed and come to work. But I would think that, that especially with the governmental agencies, that they may do some drug testing, particularly in sensitive places, like if it's a security type position, things of that nature. I think the expectation is, that you're not going to be able to do that.
Well, I can tell you this because I've had this happen to a couple of clients. If it's a federal agency, or if it's a federal type agency, obviously they're going to say it doesn't matter whether you have one or not. You can't do it. You can't even have it.
And if you had anybody like, let's say, a police officer, like City of Miami or Metro Dade, or local,
Well, that's what I was going to get to next. What's happening, which I don't think it's codified, but what's happening is certain organizations get federal funding, and that federal funding is conditional upon everybody who works for you following federal law. So let's say, for example, I know that the University of Miami will not hire you if you have a medical marijuana license, just because you have the license, because they get a lot of federal funding, some of the departments. So the department that gets federal funding, just the fact that you have the license disqualifies them, so they won't hire you. So that's something that you got to consider, but it's not the law, it's just that specific agency company.
So I guess the pro tip for this is, for the folks who are listening who want to be able to basically recreationally use or medicinally use marijuana, consider that when you're voting.
Right.
When you're looking at the people that you're going to vote for, one of the criterion that you might want to know is, what is their position with regard to this? Remember, we started this show by talking about, I touched on the Volstead Act. And of course, I'm neck deep in Boardwalk Empire right now, so it's at the top of my mind. But if you haven't seen that show, it's absolutely outstanding. I'm just watching it for the first time now. But it has been an ongoing prohibition as far as the federal government is concerned, right, just like it was with alcohol. There's really no difference. But with that, I want to talk about differences, Jeff, if you can give us a little insight with regards to other products, not just THC products. You have knockoff products, like things like Delta 9 or straight up CBD protocols or hybrid products. What's the overriding concerns and scoops with that sort of stuff?
Well, on the federal law, well, first of all, let's start off with the concept of Delta 9. So if you look at, a THC molecule, it's going to have hydrogen, oxygen, carbon in different configurations.
Look at Jeff with the big brain.
Look at that.
Yeah, in terms of that molecule. Yeah, and depending upon the position of the various elements, the most common and the one that everyone likes best is Delta 9 THC, and that's the most common THC that's contained in flour. When they take the flour and they squeeze the oils out of it, the concentrate is Delta 9. When they put that into edibles and things of that nature, that's all Delta 9. In the case of edibles that go through the liver then converts that particular molecule to something called 11-hydroxy-THC. And by the time it gets back to the brain, that's why you sort of have that very powerful roller coaster ride that a lot of people don't like, because the brain is not getting the delta 9 THC, they're getting 11-hydroxy THC. But it starts as delta 9 in any event. On the federal law, there's something called analogs, and that is if you had 100 pounds of delta 9, or if you had 100 pounds of delta 8 or delta 10, those two are analogs of delta 9 THC, and they're just as illegal as delta 9 THC because they're called analogs, and there's a law having to do with analogs. However, in the state of Florida, what's illegal without a doctor's recommendation, prescription, registration card, and the like, what's not illegal are delta 8 THC, again, a slightly different molecular configuration, essentially a much weaker form of THC, delta 10, also slightly different configuration, also a different kind of effect, nowhere near as powerful, and so forth. So those are not illegal, under the law, but you still have, all of the things we talked about in terms of impairment. It doesn't matter if you took a few shots of tequila or a whole bunch of delta 8. If there's something, like a DUI, for example, that impairment is the standard, then impairment is impairment. So those things are still.
And that may also come to play in terms of probation or court appearances, right? Because if you're out on bond, if you're on pretrial release, the court can call you in for a urinalysis at any point in time. And if you're serving any community-based penalty, then your probation or parole officer, community control officer, or whomever can similarly call you in at any time for a urine sample. You have no right to say no, and you may wind up being violated for what you thought was legal when in fact it isn't.
As a pro tip, I wanted to mention a practical matter. I ask you, Jeff, because my understanding in talking to probation officers and prosecutors in the lab is that right now the county labs or the police labs cannot differentiate between 8, 9, and 10. And so if you get arrested, you would have to foot your own bill to get it tested in a way that can differentiate, and then have the lawyer who can hopefully successfully explain this to the court in a motion to dismiss. Am I wrong?
Not only are you not wrong, double negative, you are right. But to take it a step further, for those of us who look at toxicology reports, sometimes you'll see that it's positive for cannabis.
Right.
Hemp will come up positive for cannabis. Yeah, because the labs do not try to distinguish out THC. What they're essentially doing is just testing for a positive or not for cannabis. Right. And as we know, the CBD cannabis is all completely legal, whereas the cannabis, THC is not. And they can't distinguish between the two of those things.
So that leads up to
Mike, but to reiterate as a practical matter for our viewers that are not lawyers, don't go based on somebody telling you, well, I got, a Delta 8 and that's legal, and think, okay, I can take this, I can have it in my car, I can smoke it, I'm good, because it's not going to help you. It's going to smell like marijuana. The cop's going to search. He's going to see marijuana. He's going to arrest you. They're going to take it to the state attorney. They're going to take it down to the lab, and the lab's going to say, sorry, THC, you're done.
So once again, the pro tip is, don't assume that you're going to be able to walk away from the incident. You may beat the rap in the end, but you won't beat the ride. And the ride is what really costs you right up front, out of pocket.
Right.
Time, money, effort, energy, stress, aggravation, all easily avoidable.
Right.
So that's the pro tip there. I think the last thing that we have time to hit up, because we're coming up on it, Jeff, but I would love for you to give us, I know you're not Nostradamus, but you've already proved how big brain you are with the protons and the neurons and the morons and all the stuff you were throwing out there. As far as a trend, Florida is an evolving state, just like everybody else, or devolving, depending upon where you look at it from. But we see different trends in all sorts of stuff. For instance, we've trended now to the constitutional carry. Where do you see us going? I know that they've attempted to pass recreational marijuana many times unsuccessfully. Do you see us getting there at some point in the near future, or is that just way out still in the periphery?
Well, for Florida, my prediction is that recreational will be legal 2 years from now.
You heard it here first, folks.
I'm Jeff.
2025. So you think we're heading that way? And I think it's fair to say, again, if you all remember the numbers I threw out earlier in the show, there are 38 states that have medicinal, Florida being one of them. There are 23 states that have gone even further and have not only medicinal but recreational. And there's only 6 states that are still holding out, with no legal weed of any kind. So I think as a nation, we clearly see this trend.
Right.
Look, I'm a firm believer in giving the people what they want. We could have had a show discussing intellectually the pros and cons, the savings to law enforcement, the crippling to the illegal market, to various nefarious cartels, etc. All of the potential positives that we get by decriminalizing and not having to spend time and resources and enrich the exact opposite side. But that's another subject for another day. I hope that we've been able to give our audience a pretty good idea of what the status of the law is in the state of Florida, what we see in Colorado, what the trends are in the country, and as Jeff has predicted, what we can expect in approximately 2025 here in the state of Florida. I want to thank you guys for participating today. I think this was a great show. I had a great time doing it. Jeff, I can't thank you enough for taking an hour out of your Monday. I know as practitioners, Mondays can be really difficult for us, but it's obvious that none of us are in trial. It is summertime, pretty much. So either way, we do appreciate it very kindly. And I hope that you would consider coming back at some point, and especially if we wind up with your prophecy coming true.
My pleasure. Great show. It's always wonderful to share time with both of you.
Thank you, Jeff. Same here.
All right, guys. Thank you very much. Please, next week, a little programming note. There will be no show next week. We are showing deference and respect for the Juneteenth holiday, but we will be back on the 26th. We do have a guest appearing on that show as well. So enjoy the next 2 weeks, everybody. Be safe, be sound, and thank you for letting us tune in and be at your service. Thank you again, Jeff. Thank you again, Ed. And we will be posting links to YouTube and all of the various social media as soon as we're done with this live presentation. Take care, y'all. See you next in 2 weeks.
Good seeing you, Jeff. Bye.